Okay, Chapter 16, Civil and Criminal Law. Civil lawsuits, the plaintiff claims to have suffered a loss or injury to themselves and seeks damages. The defendant argues either the loss of injury did not occur or that the defendant is not responsible for it. So just remember, plaintiff is the person who's making the lawsuit, defendant is the one defending themselves from the lawsuit. Process in a civil case, your lawyer files a complaint, the court sends the defendant a summons, the defendant's attorney files a written answer. Then they go through a process of discovery, basically investigating, figuring out what happened. Attorneys argue the case in court, and then the court gives a verdict. Pretrial hearing. Oftentimes you can have a resolution before a case goes to court. If your case is strong, the defendant may want to offer you a settlement. This happens a lot of times, especially with larger companies, in which the parties agree on an amount of money the defendant will pay to the plaintiff. You have mediation, which is two sides finding a solution with the help of a mediator. And then you also have arbitration, which resolves the dispute. Arbitration takes on the role of judge in this case. Criminal trials must prove the defendant guilty beyond a reasonable doubt, whereas civil trials have to basically just present only a preponderance of evidence. Basically, you have to present enough evidence that it's more than likely that the person is responsible, versus criminal trials that basically need to be beyond a shadow of a doubt. Criminal cases, the government is always the prosecution. The person accused of the crime is the defendant. The crime has to be an act that has broken federal or state criminal law. And then usually the penal code spells out the punishment for whatever crime they are convicted of. Types of crimes, we've already talked about misdemeanors and felonies. Misdemeanors tend to be smaller, less serious crimes. Felonies tend to be more serious crimes. Okay. Misdemeanors are things like gambling, speeding. Felonies tend to be like, murder, kidnapping. People convicted of felonies may lose the right to vote, may not possess a firearm, may not serve on a jury, or may lose employment opportunities in the military, law, teaching, law enforcement, basically working with the government. Penalties for crimes provide the punishments that a criminal pays for an offense. Criminal penalties also help prepare lawbreakers to re-enter society after their prison terms have ended. Sentencing, we've talked about parole. It's where prisoners are granted early release after serving part of their sentence. And then you also have mandatory sentencing, which means that judges must impose whatever sentence the law directs. Sentencing, you have suspended sentence, probation, home confinement, monetary fine, restitution, work release, imprisonment, also death. So a lot of different options for a judge to give out for a crime. Shock incarceration, it involves a shorter sentence and participation in work, community service, education, and counseling. Usually it involves intensive supervision via probation or parole, and then also you have house arrest. Criminal case procedure, you get arrested, you have a preliminary hearing, you have an indictment, you have an arraignment, you have trial, and then you have acquittal, or if you're found guilty, you have sentencing. The arrest, you get arrested. Sometimes an arrest warrant is issued. You get read your Miranda rights. You get booked. You can call your lawyer, or basically you get your one phone call. You get your photograph taken, and you get your fingerprint. So you get entered into a database. Hearing, indictment, and arraignments. The hearing is a suspect shows up before a judge and bail is set. The indictment is whether or not they're going to choose to charge you, and then the arraignment, the defendant is formally charged and asked to enter a plea during an arraignment. The defense lawyers interview witnesses for the trial. They study the laws affecting the case. They look for precedents. They gather information. They go through testimony through the trial. The other side, both sides are allowed to cross-examine any witnesses or any testimony. And then each side makes a closing statement, and then comes the next part, which is the verdict, the sentencing, and the appeal. So the jury then goes to the jury room. They reach a verdict. If they find them not guilty, then they acquit them. If they cannot come to a decision, that's called a hung jury. If they do find them guilty, then they set a date for sentencing. And then the victims of the crime are allowed to make statements about the sentence. And then later on, we've talked about this before, you can appeal a guilty sentence to an appellate court. We have juvenile delinquency. Basically, juveniles are considered under the age of 18 in most states. Some states have it where it's under the age of 16. Juvenile delinquents are young people who commit crimes. In some cases, they're tried as adults. Usually, poverty is a common factor across most juvenile delinquents. The juvenile justice system, the juvenile court system hears cases. The goal is to rehabilitate and correct the behavior before they become adults. There are two types of cases in juvenile courts. You have neglect, which the court has the power to place use in foster homes because their family that they're staying with now are being neglectful. Or you have delinquency, which are juveniles who commit crimes. Basically, it includes running away, violating curfew laws, or just violating laws in general. So then you also have diversion or detention. So specific officers and police departments handle juvenile cases. They have the power to divert juveniles away from court and into special programs. Usually this would be considered like community service or getting involved in a special program instead of serving time. Then there's also detention, which would be like, you go to a juvenile detention center, aka jail. There is also counseling, job training, drug treatment programs that would be considered diversions. The trial, juveniles attend the preliminary hearing. Juveniles are not entitled to a jury trial. The judge alone makes the determination of whether the juvenile is delinquent. The juvenile cases are closed to the public. So usually anything up until the age of 18, you cannot, like, even if they run a background check, people won't find out what you did prior to, if you committed a crime as a juvenile. Those records usually get expunged, which means nobody can see them outside of the court system. Sentencing, juvenile found delinquent or guilty, another hearing is held, the equivalent or equal to sentencing. They may receive a stern lecture and sent home. They may place offenders in a special training school, treatment center, or teen shelter. This would be like the diversion. Or they could have a completion of a sentence, charge dropped, and removed from the record, which would be like the detention. Supreme Court rules in Re Gault established that juveniles have the same rights as adults under the 14th Amendment. Bill of Rights is not for adults alone. Juveniles have the right to counsel, they have the right to confront witnesses, and they have the right not to be forced to incriminate themselves. So here are some practice questions. The statement naming the defendant and plaintiff and announcing the lawsuit is called a summons, complaint, settlement, or penal code. That would be a complaint. Blank spells out the punishments they go with each crime. A summons, complaint, settlement, or penal code. That would be the penal code. After serving parts of their sentences, some prisoners become eligible for early release or parole, acquittal, discovery, or arraignment. Parole. The primary role of juvenile courts is to punish, arraign, acquit, rehabilitate. That is rehabilitate. Which of the following situations may lead to a negligent suit? And I'll let y'all read them. That would be a worker is killed on job when equipment fails. According to studies, which young people are most likely to get in trouble with the law? Older juveniles, abused children, mediocre students, or middle-class teenagers? That would be abused children. What right do accused juveniles not share with adults? The right to counsel, the right to a jury trial, the right to confront witnesses, the right to refuse to incriminate themselves. The right to a jury trial. When does an accused person enter his or her plea of guilt or innocence? On being arrested, during booking, at the arraignment, or during cross-examination? At the arraignment. And that's it.